from the Unreasonable Doubt Studios, in association with Spitner Productions, this is Laying Down the Law with your host, Billy DeClercq, and co-hosts, Kristen Drenning and Curtis Rutherford. Featuring a jury of genius jokesmiths and paneled with the help of Publishers Clearinghouse, auditors from the firm of DCH Lottery Management, and selected by random draw from a hermetically sealed mayonnaise jar every Tuesday and Thursday at never. Only a madman would bring these people together to construct an entire virtual world of law and order, simply to tear it asunder with ruckus laughter. That madman is attorney Billy DeClercq. The result is a podcast blasted to the farthest reaches of the interwebs. That podcast is this one, and it starts right now.
Welcome to Laying Down the Law, a comedy podcast hosted by me, the persimmon-loving chipmunk of the Supreme Court, Billy DeClercq.
And I'm co-host Kristen Drenning, actual lawyer, storyteller, improv teacher, person who is very in communication with the bats. And today we welcome back to the pod my friend, comic, actor, improviser, Henry David. He just completed a successful run of The Hunchback of Notre Dame at SMC Theater, and he's currently performing at West Side Comedy Theater every Monday.
I am thrilled to have you back on the show, Henry, but we did forget one of your credits. Here, I'm just looking at your Wikipedia page. There's something on here about Dadarungi, Seoul Korea's bike sharing system set up in 2015, also known as Seoul Bike. So can you tell us a little bit about your credit with respect to, is it Dadarungi, Seoul Bike? Can you tell us how'd you get into that?
Oh, yeah. Well, so I have a buddy of mine. He works at this company called Young One in Seoul. They're an outdoors company, and he had moved from the United States a couple years ago, and I went to go visit him because we were such best friends. And he introduced me to this whole Seoul Bike apparatus. There was a lovely lady that worked down there. Her name was Kim Seoul. She was the proprietor of this idea, and she really got me into it because I was sort of out of shape, and I don't know. We kind of connected, like our souls connected in Seoul, and I don't mean that as a pun. And so I have this on my profile because she laid me next to the Han River after a nice long bike ride, and she took my virginity.
Right, and you'd want any prospective employer to know that, of course.
That's on your resume.
Yeah, I just really need people to know that I've finally gotten that out of the way.
Nice.
Well, it's great that we have that link to the Wikipedia random page within your profile there. And I'm so glad to have you back again.
Thank you.
Absolutely. It's always a pleasure. If you're interested in finding new approaches to representing yourself in court, you may want to check out Sovereign Filing Solutions. Sovereign Filing Solutions will help you represent yourself. Make the following argument. Courts only have jurisdiction over two kinds of criminal claims, common law and admiralty or military tribunals. And because there can't be common law claims because there's no aggrieved party, and the people or the state or commonwealth don't count because the judge, who's an employee of the state, has to recuse himself from the proceeding. So the professor who's explaining this, by the way, who's a gecko, if you look up Sovereign Filing Solutions.
Wonderful.
Professor Gecko tells us that statutes can never be the basis for a criminal action because they're not in the Constitution or something of that nature. So you essentially go to court and you tell people that the court has no jurisdiction over you. And that definitely works.
These are sovereign citizens, right?
Yeah, I was going to say, as a person currently living in Texas, this hits very close to home. I am but a 45-minute drive from Waco. But yeah.
There's another approach out there saying that the flag of the United States, because it has a fringe on the flag, the courts are secretly imposing admiralty law on us all.
Oh.
And because the United States flag with a knotted golden fringe on 3 sides. And because the judges will not take out the gold fringe flag and replace it with the constitutional flag of the United States, which has no fringe, therefore that's legal notice to all who enter of the type of law that has jurisdiction over the court. Only the constitutional United States law signifies common law jurisdiction, whereas the gold fringed United States flag is an admiralty or war flag, which denotes admiralty or martial law.
Wow.
Unfortunately, this
Okay.
does not work, and this is a case out of Texas.
Yep.
The federal court has weighed in, and I quote from United States versus Greenstreet, a 1996 case. Others have attempted to persuade the judiciary that the fringe on the American flag denotes a court of admiralty. In light of the fact that the court has such a flag in his courtroom, the issue is addressed. The concept behind the theory is the proponent asserts that if the courtroom is adorned with a flag which happens to be fringed around the edges, such decor indicates the court is one of admiralty jurisdiction exclusively. To think that a fringed flag adorning the courtroom somehow limits this court's jurisdiction is frivolous. See Vela versus McCammon, describing petitioner's claim that the court lost jurisdiction because flag was fringed as, quote, without merit and, quote, totally frivolous. Unfortunately for defendant Greenstreet, decor is not a determinant for jurisdiction.
Seriously, I love this cause. This is the greatest case I've ever heard of. It makes me want to go crafting. Makes me want to get myself to a Hobby Lobby right now and talk about it with everybody I meet there.
For those of you who are lawyers listening to this, the citation is 912 F Sup 224, Northern District of Texas, 1996. Thanks to Above the Law for providing that tidbit.
Awesome.
And that is not the case of the week. But, I think, Henry, the next time, anything happens, you go into court, whether it's a parking ticket or you drive 127 miles an hour on the freeway, just, take a look and see if the flag is a fringe. And, you should try out this theory. I think it would be, it's a really good idea.
Oh, no, my advice is the opposite. I say, Henry, you get in there, you notice that fringe, and then you adapt. You come in a little sailor suit and you lean into that admiralty. Okay.
Or just turn right back around and leave.
And leave.
Mm-hmm.
Yeah.
All right. Well, the case of the week this week concerns the difference between liquidated damages, which is a clause in a contract that allows for damages to be calculated at the outset of the contract in some specified amount. So liquidated damages clause says essentially that because the damages that would flow from breach of this contract are hard to calculate, we determine in advance that the penalty for breach of this contract will be X number of dollars. That's called a liquidated damages provision. That's distinct from an unenforceable penalty clause. A penalty clause is a clause that says, if you breach this contract, the consequences for breaching the contract will be X number of dollars. Sounds similar, right?
Yeah, very similar.
Very similar.
So the test the courts use to distinguish the two is whether there's a reasonable relationship between the provision, the amount of damages that are allowed for in the contract, and what the actual damages might be. And so, for example, if you have a contract that's a loan of $500 and you're supposed to pay it back in 10 installments of $50 each, and there's a liquidated damages clause that says, if you breach this contract, you'll be liable for liquidated damages of $10,000. That would be an unenforceable penalty clause because the amount that was borrowed is $500. The payments are $50 each, and $10,000 is not. Doesn't have any reasonable relationship to the actual damages that would be that would occur in the event of a breach of the contract.
Are liquidated damages clauses typically not used or regarded?
They're very common, especially in construction contracts or in contracts where it would be hard to calculate exactly what the costs of a breach would be. One place you might see it is in a non-disclosure agreement because, for example, if you disclose someone's confidential information, it's hard to figure out exactly what the damages are because you have to go and find out, where was it disclosed? Who was it disclosed to? How did they use it? What are the monetary damages for that? So you have a liquidated damages provision that says each time you have a disclosure of these, trade secrets or confidential information, we agree in advance the liquidated damages to be $1,000 or $10,000. And that way, if you are the person who's trying to protect the information and someone then discloses it, you can go to the court and you can say they disclosed it, and my liquidated damages are this much. So I don't have to go prove what all the actual damages were. How was I actually harmed by this breach of the non-disclosure? It might be very hard to show that. If it was a treatment for a movie and then the movie ends up getting made by somebody else and you lose your rights, you may actually have damages that are a lot greater than liquidated damages provision. But it's hard to calculate exactly, well, how can you prove that the movie would have gotten made had you been the one to pitch it, as an example?
Mm-hmm.
Does that make sense?
Yeah.
I was just thinking to myself, but maybe I should save this kind of gold for comedy court. But why is it on a policy level that we would not want to allow people to punish people who break contracts, however they please?
Well, you are you are a Texan and you're all about freedom of contract.
That's right. Yeah, that's right.
I think the concern comes from contracts that are extremely one-sided, like think of an insurance company, or I don't know, any kind of click wrap or browse wrap agreement that you click every single day on your phone or computer. Those contracts that you never read, that are one-sided and not negotiated.
Right.
If those type of contracts had some kind of really, really onerous liquidated damages provision, you might want to argue that was unfair because, and the term we would use, the legal term would be unconscionable, because you really didn't get to negotiate the contract at all.
Got it.
Loan contract is another example too, where the bank's going to kind of set the terms. They're the one that's loaning you the money. And, when you think about how exorbitant credit card rates are already and the ridiculous, overdraft fees, you can get like 9 of them in a day. If you aren't careful, it's already pretty one-sided against the consumer. And so in those situations where there's real uneven bargaining power, we would want to, as a society, disfavor penalties that don't have any relationship to the actual damages. That's my thinking on it.
Yeah, that makes sense.
Going back to the construction example that you made earlier, so I know that it's very commonplace for if for example a construction company goes over the allotted time that the project was supposed to take for it to be completed, then they'll have this type of like daily penalty for the amount of time it goes over the I guess the closing date of the contract. So, or the time the project is supposed to be complete. Would that be considered the form of the liquidated damaging or damages sort of clause?
Well, it depends on which side you're on. If you're on the side of the contractor, you may want to try and argue that it's an unenforceable penalty provision that bears no rational relationship to the actual damages suffered by the developer. If you're on the developer side, you're going to say that every day that our project isn't completed, it's costing us money. So liquidated damages are one of the most common places where liquidated damages clauses come up. And so, yeah, that is exactly an example of a liquidated damages clause, because late completion of a construction project obviously does have impacts on the person who's contracting for, thing to be built, right? If it's let's say it's a high-rise housing unit or something, it's got 1,000 apartments in it, a couple of weeks of delay, if their project gets delayed, then they, could lose permitting. They may not be able to rent out the units. So they're losing the future rent and they're incurring carrying costs on the building loan. And so all those different kind of costs are packaged up and put into the liquidated damages clause. Construction contracts are, a huge area for, both writing them and for litigation, because there's multiple contingencies and issues that come up, delays. And, in fact, my father, who does occasionally listen to this podcast, has an extreme level of interest in and experience with construction contracts, specifically delays, rain delays, and the litigation that could flow from there. So, yeah, okay. Great question.
Thank you. That'll be my only great question today.
I hope not. Yeah. I hope not. Well, are you ready for the case of the week?
Yeah, let's do it.
case of the week is lawyer versus lawyers.
Mm-hmm.
And in preparing for this, I do actually occasionally prepare for my podcast. In looking up this case, I did find out that the law firm does still exist. I didn't look up the lawyer, but the case is Ashcraft and Gerel versus Coady. And this is DC Circuit case from 2001.
It was a bad year.
Yeah.
Mm-hmm. Yeah. So this is a dispute between Edward Paul Coady, who's an attorney, and the law firm of Ashcraft and Gerel, and it comes out of an arbitration award. In the arbitration, or in the underlying case, what came out essentially was that Coady had been the managing partner of the Boston office of Ashcraft and Gerel. He was fired in April of 1998. At that time, he was the managing attorney and had been since 1993. But in 1997, a number of disagreements about his compensation and his management of the office flared up. And in July of 1997, Coady complained because they had failed to pay his semi-annual bonus. And the main thrust of the case has to do about a fight that we're not even going to talk about. Essentially, what the firm did was they cooked the books to make his bonus smaller. They split the expenses between 2 years so they could give him a smaller bonus. Coady, not to be outdone, essentially worked on stealing clients and trade secrets from the firm while he was still there, working with an associate, basically stabbed them in the back.
So just lawyers being lawyers, really.
Yeah, lawyers being lawyers.
Yeah.
So the case is pretty long, and concerning the different disagreements that they had. Specifically, the evidence that related to specific acts of misconduct included Coady's attempt to steal clients and sabotage the firm's computer database. He had a conspiracy with a former associate and did not inform the firm the associate had left the firm. And then Coady tried to show that the firm had planned to kick him out for a long time. He had evidence of all these discretionary firm decisions that had worked to his disadvantage. They had basically manipulated the calculation of income and expenses to minimize his bonus. He ultimately had been awarded $45,000 in unpaid bonus, and that the firm ultimately had tried to drive him out, and it might have been a different result.
Just a quick clarification here.
Mm-hmm.
So he didn't start leveraging his insider knowledge until he found out that they weren't going to pay him his bonus. And he figured out why they weren't, because he had insider information and was able to determine that they were messing with the numbers to pay him less.
That was the issue. I don't know if he started working against them earlier or later. I'm not sure which happened first, but basically, this is some serious, like the old Mad Magazine spy versus spy stuff, where they're just, as I like to say, the only ship that doesn't sail is a partnership.
I've never heard that before, but that's amazing.
First time I heard it was from a judge. She said, this case reminds me of the old saying, the only ship that doesn't sail is a partnership.
And you know what kind of ship does sail? A friendship.
A friendship. Oh my God. I love that. I love that. That's really good.
Thank you. I didn't come up with that.
Wow. So the case of the week, what we're talking about is section 4 of the decision. Sections 1 through 3. Boring. Section 4
Juicy.
is Coady's contention that the district court should have thrown out the claim for liquidated damages. The court starts out by saying that liquidated damages provisions are allowed if the amount agreed to by the parties prior to the breach is reasonable. And they say it's hard to set a clearer test or a narrower test than the reasonableness of the sum agreed upon as compensation for the breach. So in general, a liquidated damages provision is valid and enforceable. Now, Coady did not say that as a matter of law, you can't have a liquidated damages provision. What he said was the amount of the liquidated damages provision in his contract was unenforceable on public policy grounds and is a penalty because it had no relationship to the amount of actual damages suffered or anticipated. The amount of liquidated damages was $400,000 in his employment contract. He cites to the restatement of contracts, which is restatement of contracts is a doctrine, or it's kind of like a summary of the law that has evolved from cases. So in the law, you have the Constitution that's, sets out the rules of the road at the beginning. You have statutes, which are enacted by the legislature, and you have decisional law, which is when the courts make a decision and interpret the law over a period of time. And so what the restatement does is it takes all the court decisions and it summarizes them in a short form, explaining what the law is based upon decisional law that courts have said. So it's not anything that a legislature has enacted, and the restatement itself isn't law. It's a description of what the law is. Does that make sense?
Yeah, that's what precedent is all about, right?
Mm-hmm. It's sort of like the Cliff Notes to a lot of law. It's just the short summary of what it is. So what the restatement of contracts, section 356, for you nerds who actually look things up, says this: damages for breach by either party may be liquidated in the agreement, but only in an amount that is reasonable in light of the anticipated or actual loss caused by the breach and the difficulties of proof of loss. A term that fixes unreasonably large liquidated damages is unenforceable on grounds of public policy as a penalty. Now, reasonable, for those of you nerds who go to law school or actual lawyers, nerd alert. Good God, find something better to do with your life. Just kidding.
Ouch.
But reasonable is a squish word.
Yeah.
It's a wiggle word.
Yeah.
It is where the profession of an attorney lies, is arguing what's reasonable and what's unreasonable, because what's reasonable and what's unreasonable is pretty much in the eye of the beholder. And so we have these words that we use because you can't come up with a one-size-fits-all description of when something's going to be a penalty and when it's going to be liquidated damages. So how helpful is it to say sometimes it's liquidated damages and sometimes it's a penalty? Well, it depends on whether it's reasonable or unreasonable. And whether it's unreasonable or reasonable depends on how good of a lawyer you have. Mostly.
Yeah.
By the way, I am available. I'm very good at arguing things are unreasonable.
Way to slip that plug in there.
Yeah, ABP, baby, always be plugging. Just kidding. I don't think I've ever gotten a single client out of this podcast. If anything, it drives them away. It's on my website, but whatever.
It's on your website. If anything, it'll drive you away.
If anything, yeah. If you want an attorney with no sense of humor, there are plenty of those. If you want one that occasionally cusses and makes lots of dumb jokes, then you're coming to the right place. So Coady's contention is that when the parties have one fixed sum as damages for any material breach, they should question it. Now, the DC Circuit just bats that away. They basically say, no, that's not true at all. First of all, the contract didn't say that every kind of breach in the employment agreement would trigger the liquidated damages provision. Only breaches that were, quote, material. Again, another squish word. What's a material breach? A big one. What's an immaterial breach? A little one. What's the difference between a big breach and a little breach? Depends on the size of your argument.
You'll know it when you see it. Sorry.
Yeah, know it when you see it. That's right. Here, they said, look, dude, come on. You were trying to steal from them. Okay, that would be material. Trying to steal is a material breach. Let's just get that straight. Okay? So the second thing that the DC Circuit says, it was not an unreasonable amount. They point out that when he was first hired in 1993, the amount of liquidated damages was $50,000. In 1994, it was amended to make it incremental increasing. So from 1994 to 1996, it was $150,000 for liquidated damages. 1997, $300,000, and 1998, $400,000. Increasing the amount of damages each year was justified to reflect Coady's increasing value to the firm and his increased responsibilities and availability able to steal. No, it doesn't say that. His increased responsibilities within the firm. He was not only the head of the Boston office, but he was also the only lawyer in that office with substantial experience in the firm's Boston practice areas. So you basically got Coady like running the Boston office like he's the just, I don't know, what's the equivalent of the Godfather, the Irish equivalent of the Godfather?
Consigliere.
Yeah, he's like, yeah, exactly. So they can reasonably argue that his termination for cause, meaning that he did something wrong, would likely be disruptive and cause both considerable losses and expenses, while the firm sought to replace him. In fact, one of the partners in the firm testified that the lost business opportunities that they missed out on as a result of his termination was between $1 and $1.5 million. And so the court says the district court below was right to allow the claim for liquidated damages. And there's a bunch of other stuff here, but I'm skipping all that other stuff.
Yeah. Yep.
Okay. So reasonable relationship because it was material breach, don't steal. The amount increased and it bore some relationship to the actual damages which were introduced to be proven. Questions?
So they weren't looking for the money that may have been a loss from what he was doing wrong against the company. It was more like they had to get rid of him and they lost the revenue generated by him in the interim, right, between when they had to replace him and his firing.
Right. The liquidated damages were related to his breach of the agreement.
Right. So, but like the way they assessed that was based on, okay, now we don't have the consigliere of Boston at this moment. We're missing out on all this money that could be potentially made if he had just not been fired.
Yeah. So the perspective or the point of view, what the court does is they try and look at it from the point in time that the contract was made. So what did the parties anticipate instead of looking at it from hindsight, what actually happened? Because the liquidated damages could be more or could be less than what the actual damages might be. So there's an argument here that the liquidated damages was actually maybe low. What the court looks at is they kind of in their mind, they go back in time to the time when you made the contract. So here's 1993 and then amended and basically says, if we go back in time in our minds to the time when they were making the deal. When they were making the deal, did the parties have a reasonable expectation that this is what the losses could be if the contract was breached?
Oh, I see. Okay.
So was it reasonable from that perspective at that point in time? Not what the end result was, what ended up happening, because hindsight is 2020 and all that. We're just full of the cliches today. But yeah, when the parties were originally making the deal, and they were looking at what could or couldn't happen. The example of the construction contract is also a good one. A lot of unforeseen things can happen over the life of a construction project. You could have, like we had this terribly wet winter. If you were trying to build something this winter, you would have hit a lot of rain delays and couldn't have predicted that in years past. So we're not going to hold either party responsible for things that they couldn't necessarily predict. The weather.
Right.
The weatherman can't even predict the weather.
Act of God.
So
yeah.
So, but what we're going to look at is what was a reasonable thing to think about at the time that we were making the contract. We probably assumed there'd be some rain delays. Don't know how much, but did we reasonably account for it? So let's say you had a contract that said you can have up to 10 rain delays that are no fault, no penalty. Well, there were a lot more than 10 days of rain in the past year. So in LA, so they maybe undercounted the number, but it was a reasonable guess because there's about that many rainy days in the rainy season, whatever. I don't know. I'm not a meteorologist, so I'm going to get some I'm going to get some hate mail right now from the meteorologists. Another population of people I've pissed off. I'm so sorry. I keep
God,
losing
I know.
listeners.
I mean, the big one was when you pissed off the entire Fragilist Society. From here, it's just like, it's just gravy.
Oh, yeah.
Yeah.
Oh, and I've got some more stuff for Florida later.
Yeah, can't wait.
I'm not going to get to it in this episode, but I'm just going to take a dump on Florida in one of my upcoming episodes. So
please
it's
do.
overdue. It's way overdue.
Yeah.
But there's so much to choose from, but yeah.
Here's my question that pops out to me is, they say it's appropriate for the liquidated damages to increase over time because that reflects properly this guy's increased standing and importance in the firm. But I'm like, what's the consideration for this guy, like that he has to be subject to increasing damages, right? Like why would he submit to that if he's not getting paid more under that contract necessarily?
Well, I think
insulated.
Yeah, I mean, I don't have every term of his contract, but he had increasing responsibilities. He was the key person in that Boston office,
right?
And he was basically supervising everybody. I don't know what his bonus structure was.
Yeah.
Do we know how much his salary was?
$1 million. No.
Yeah, I don't know. I'm not sure.
Well, I don't know. If you're the head of a whole office like that, I'm assuming it's not.
I think I saw that the claim below was for $500,000. So something, it was not, it was a high. Yeah.
Yeah. I'm sure he was making plenty.
Yeah.
All right. So examples for liquidated damages provisions you might see. You might see liquidated damages for late delivery of a product. So a business agrees to sell a product, but they don't deliver a product on time. The buyer could be entitled to liquidated damages for losses because they could miss the market. If you're selling, like some kind of toys and you miss the holiday season, then you could be in real trouble. So it could be a percentage or it could be a set amount. Failure to provide a necessary service. You're going to hire a roofer and, you don't want I guess I'm a little focused on the rain today, but you don't want your roof to leak. And, if the roofer doesn't come, you're going to be out of luck. So you agree that it's difficult to find other roofers, and so you're going to have a liquidated damages provision. Late payment, we mentioned before. This is where you will probably most likely see them, where you have a late fee. If you have a credit card and you pay it late, as I have done, there's a late fee. I don't anymore. I have an auto payment, but there's a late fee, $40 or whatever. That's essentially liquidated damages. Okay, that's not, the credit card company would argue it's not a penalty. I don't know what damages they're really suffering if you're paying 1 day late, right? But it's a specific amount of money that is owed by the party who's late. A lease rental agreement can have a liquidated damages clause, and they often do. If your rent's due on the 1st of the month, you pay it before the 5th, then on the 5th, there's a 10% penalty. It's very common. And that's a valid liquidated damages provision because the landlord is going to have to send a notice, is going to have to, follow up. And so they're going to typically get that. Although if you have a decent landlord and a good excuse and you're a pretty good advocate, maybe you get a break the first time. The idea is that it has a deterrent effect, a late fee. So it's something that, could be waived or, encourages people to pay on time and perform their contract.
It seems fair and just.
It's basically credit card companies and the like Pavlovian training us, right? To like you get zapped enough times and you stop submitting late fees, right? Submitting your credit card payments late. Yeah.
Yep. Exactly. Copyright or trademark infringement is another area you see a lot of liquidated damages because intellectual property, the losses can be very hard to calculate. If you lose your rights to something or, or trademark infringement, that kind of thing, you can agree to a certain amount. So those are just a few examples of the types of liquidated damages clauses you might see.
Some of the liquidated damages that you can avoid, you can look forward to enjoying in your adult life. Yeah.
It sounds all too normal. I definitely argued my way out of, I don't know, for some reason, the auto pay that I'd set up, I thought it was set up, but long story short, I had to get a new card. And I guess because the new card, it just, I had to set up the auto pay with that new credit card. And so I had $100 late fee and I argued with them and they were like, all right, we'll just take it away because we just don't want to have to talk to you anymore.
Yes. Annoy them into submission. Works all the
Yeah.
time.
So in a way, it's Pavlovian in the sense that it teaches you how to be annoying.
Yeah.
Mm-hmm. All right. Well, we're going to take a quick break. You can go take care of your liquidated damages while we take this break if necessary. And when we come back, we'll have Comedy Court. Is a very childish joke. I'm sorry. When we come back, we'll have Comedy Court. And we're back. Welcome to Comedy Court. All rise. The courtroom of Superior Court Judge William DeClercq.
And might I say, you're looking very fine, Your Honor, just on the record.
Thank you. Well, I think let's start with the Pledge of Allegiance. Oh, we'll skip the Pledge of Allegiance. We already got that. Okay. Well, let's see. I've got in front of me today. I've got the case of Ashcraft and Gerels against Coady. So go ahead, Coady. State your case. Go ahead, Coady.
May the record reflect that my name is not Coady. I am neither a delicious kind of beef nor an all-time excellent basketball player. I am Coady, a man, a simple man, a man coming up against a juggernaut of a law firm who was bent on doing me wrong, whilst I was single-handedly and backbreakingly running all the game and all the points.
Your Honor, come on, we're not going to go through a monologue
the bench
here.
Will recognize Ashcraft and Gerel.
What?
Well, look, I don't think it's appropriate for her to have a little monologue here. That's a completely baseless lie that she's spewing. So can we just move forward with the initial arguments here?
Your Honor, I object to this
the law
objection.
firm of Asco and Gerel.
Thank you, Your Honor. Listen, this is a pretty open and shut case here. Okay, the defendant clearly was stealing from the company, sharing trade secrets, and in the contract there's a liquidation damages clause, which he signed. I don't see how. I mean, there's nothing more than that.
Okay, objection. I'm sorry. I have to come back in here, Your Honor, because I
was thinking about developing a product, and maybe you people can give me some advice about this, Mr. Kobe's and Mr. Asco. So I was thinking about a drink, like a sports beverage called Liquid Damages. That would be, we could advertise it and market it. Maybe you, Mr. Coady, you could,
Your Honor, I would
do a commercial or something, and and I could just get a cut of the profits. What do you guys say? It's go into business together.
I would be honored to go into business with you, Your Honor, but not with these twisted fools over at Ashcraft and Gerel or whatever it's called.
Look, Your Honor, I don't see any future with this person. I mean, look, right now, that is a suit. This defendant is wearing a suit that used to be company property. Right now, we bought a whole bunch of those suits at Brooks Brothers, never returned it.
From the little boys section, Your Honor, they did not even spring for me to get a full man suit. I mean, it was.
Speaking of little boys, this reminds me of a really good joke I heard the other day.
Yep.
So there's two ships passing in the night. One's a friendship and one's a partnership.
Which one of those ships sails, Your Honor?
Well, a friendship is the one that sails, because a partnership is the only kind of ship that doesn't sail.
Yes, and this ship has sunk. Ship has sunk.
That is
point
true.
Of honor, final point of honor, I will just say the following thing. If we're really talking about the liquidated damage clause here, and we're talking about reasonableness, how reasonable is it for a law firm not to anticipate their managing partner, who does all of the work and handles all of the cases out of their Boston office, is not going to steal from them? How reasonable is that? Very unreasonable, in my opinion. All lawyers know lawyers. Lawyers know lawyers. So,
wait, hold on.
No honor among thieves. What say you, Ashcraft?
Your Honor, my cell phone's missing. But I could have sworn I put it on this table over here. Your Honor, I know this is a little weird, but could you just dial this number for me, please? You have your cell phone on you.
Yes, 888-555-1234. That's the Ashcraft and Gerel. I have you on speed dial. Anytime if I get hurt, I'm going to be. I don't even
pardon
look
me,
at
Your Honor.
Yep.
I appear to be getting several phone calls.
Hello.
Hey,
that's my phone.
I really like that idea about liquid damages, the energy drink.
Thank you. I think it's a fantastic idea too.
Sure.
Do you think we could get
conversation with him?
Do you want to conspire together? I'm just off the record. I'm interested in stealing some trade secrets from Ashcraft and Gerel and using them to fund this sports drink. I'm just telling you.
Well, this sounds like a fantastic idea.
Yeah.
All right, I'll announce my decision from the bench.
Yep.
The court has read the papers of the parties, has considered the arguments of counsel, and has come to the following decision. Number 1. Ashcraft and Gerel has a very handsome lawyer.
Yeah.
Number 2, Coady has excellent taste in sports drinks.
Thank you.
Number 3, I will be personally having the liquidated damages provision paid to me via my bailiff. I'll send the decision in the mail.
Did we both lose?
You did. The court's going to be taking the liquidated damages under submission. Thank you very much. Goodbye.
They don't call it comedy court for nothing.
Excuse me. There, Attorney Coady. You just announced you just were a loser in comedy court. What do you have to say for yourself?
I will tell you that the judge was nothing short of a bozo. That I plan to take his liquidated sports drink idea to the bank. And I will not be paying him any sort of compensation for that.
I need to get a comment from the attorney for Ashcraft and Gerel. Sir, you also lost. Do you have a comment?
Yeah, I can't. For the life of me, I can't find my keys anywhere. I swear to God, they were in my breast pocket. This is really frustrating because I got to go pick up my daughter from school.
Check out my new Tesla. I just acquired it.
Bailiff, we got a goddamn thief in our midst.
Do you need a ride?
I'm gonna take a ride from you in my own car. Give me my goddamn
Actually,
keys.
I actually do, and probably the judge does too. So let's get out of here.
All right. See you later, Ashcraft and Gerel.
And that was comedy court.
And then we rode off into the sunset. I was going to say my on appeal, I think I would raise probably on appeal of the appeal, which is a thing.
An appeal of the appeal, yeah.
Yeah. I would raise that, of course, there was no jurisdiction. Now, this is not a claim I need to have at any point raised below. I will raise it now, and it will say fringe flag, Admiralty Court.
It's well known that comedy court does not have a fringed flag. That's something that just, so had that come up, it just wouldn't have gone anywhere, wouldn't have flown.
Oh, nice.
No pun intended.
Oh gosh.
Mm-hmm.
You know what? That sounded like a frivolous pun to me.
Yeah. The only ship that doesn't sail is an Admiralty flag in court. That's the only ship that doesn't sail.
Oh man, that dog don't hunt.
I think there should be. I imagine a pirate flag, like a skull.
Can you imagine what like a conservative, like a survivalist group would do if they walked into a courtroom and in lieu of the American flag, there's just a giant fringed Jolly Roger?
Yeah.
By the way, producer Jeff is a Navy vet, and he's got everything. I don't know how often we come with like really lame, idiotic comments that show that we've never been off of dry land, like ever. Jeff's like, I usually listen to these like, oh my God, I'm going to kill these people. They do not know what's going on.
No.
We'll just insert a comment from Jeff right here.
Producer Jeff here. My lawyer has advised that I should not respond to any commentary in this episode.
Thanks for that, Jeff. I don't know what you're going to say, but what you said was brilliant.
Jeff, you're great.
He is great. You know that? He really is. He really is.
So much gusto.
He does. It just, Are you ready for some improv?
Yes, I am. Yes.
I'm gonna do some improv. Okay, warm up.
Dad, I have something to talk to you about.
Sure,
Yes,
sure, honey,
daughter?
sure.
Yeah, my two
well,
dads. Thank you.
Right.
Yes.
Mhm.
I love you so much.
I made a mistake.
Yes, I love you too.
I got a really cool new special edition Britney Spears credit card, and I didn't read the fine print, and I was late on the payment, and now they're telling me I need to give them my kidney, and I don't know if I can spare the kidney because I'm getting towards kidney failure already.
Well, all I can say is, oops, you did it again.
Oh,
Yeah,
Dad,
well,
but I'm not yet a
Good one,
woman.
Thank you.
well, this
Go
is
ahead,
this
darling.
is
This is your expertise. The whole parenting and advice giving. I just do the puns.
well. I am the more matronly of the two. Listen, I'm not gonna lie. I'm a little disappointed in you, for not coming to us first before signing up for a Britney Spears credit card because you
Cry me a river. Cry me a river, okay? I have a right because I'm not a girl, okay?
Wait, is that another Britney Spears reference?
Yes.
Clearly, you've got the pun skills from your father. I mean, this father, not your other father, right? But if I knew more Britney Spears songs, I could make more Britney Spears puns.
That's a good one, sweetie. Listen, I'm disappointed because you realize that we're both your fathers are lawyers, and what did we always tell you?
Look out
Read
for
it.
liquidated damages clauses that have been one-sided and not well negotiated by either party.
Yes.
Well, what I just want to know is, have you charged up your entire Kevin Feder credit line?
That was a toxic reference that I refuse to acknowledge.
You refuse to acknowledge it?
It was
That's
toxic.
crazy.
Nice, very nice. You know what?
I can do it too, honey.
I got lost in the game.
So I think I've rubbed off on you a little bit.
Oh yeah, you did.
Well, I think we need to write the credit bureau. Don't you think so?
I
Maybe
think if
sternly worded letter.
Yeah, just
let's start working on it right now.
Okay.
Dear
great.
Britney Spears credit card, my daughter is only 14. What are you thinking giving her a $10,000 credit line?
And
of course
also add this: her kidneys are not for you. That's for us when we inevitably succumb to kidney failure.
Exactly. Let me just add that to the letter. Her kidneys are not for you; they are for us. Because
we like to go hard. We like to go hard at night.
That's right. We do. That's well known. Actually, maybe we should pop one open right now. I'll finish this letter. Don't you think?
Why? I mean, I'm already halfway into the cupboard.
Well, it is 3:00.
I don't feel like you gave me enough. I need you to give me more.
Well,
that's another reference, isn't it?
the Europeans do give their children alcohol at quite a young, supple age, and I feel like we're doing her right. I feel like this is like a European family, don't you, sweetie? There we go.
All I know is that this card should have been free, Brittany.
I just feel like sometimes, like, I'm being overprotected.
Cognac?
No.
Oh, thank you.
Baby, one more time. I'm done. That's it. I've got it. That's all the ones I've got.
Okay, well, let's send out the letter and let's see what happens. And this is obviously an email, not a letter, because the year is 2021. And send.
Response from Britney Spears credit card company. Would you like a piece of me? End response.
And that's all they wrote?
That's all
really
they wrote.
unsatisfactory.
They didn't even sign off.
It's a Britney Spears reference.
Yeah.
No, I figured as much. I
Yeah.
just. Mhm.
Well,
That's all they
listen.
said.
All right.
What's the? Are they really going to come over here and really? I mean, this is laughable. They're not going to actually come and try to take your kidneys since you missed a payment. They're not. There's no way somebody's going to
Knock,
just
knock, knock,
show up
knock,
at the
knock.
door.
Hello?
Hello. I'm here from the Britney Spears credit card company to collect a kidney.
Oh my
You may get in the
God!
bathtub immediately, and we will go ahead and excise the kidney from you.
You brought a
Um,
bathtub with you.
Yes, and it's ice, and there's ice here too.
Well,
All right.
according to the terms of this contract, I am a slave for you, so may
No,
as well.
no, honey. Right now is just. Let's just. Can we stop with let's stop with the
Okay.
Britney Spears puns? Okay,
Fine.
this is actually
I'm sorry.
happening.
You
This
know,
is
I
real
only
now.
taught her via puns, so that's my fault. All right, go ahead. Get in the bathtub.
No, hold on, please. This is me and my husband's only daughter. Okay. By the way, you're extremely tall. You look like Lurch. But anyhow,
Thank you. I do get that a lot.
Can I ask you how my kidney is going to help pay any unanticipated damages, to cover the cost of any damages? Are you going to sell my kidney?
Well, point of order. Miss Spears just simply likes to collect them. She's got a room in her house. I don't know if you know this, but she just collects kidneys just to look at them. So this would be the 5th one she'll have on display.
I read that she had an underground bunker that was filled with like extra organs, just in case the world ever ended.
Also true.
Mm-hmm.
that
And one of her studio albums is down there too.
Whoa.
oh,
Hopefully the one
Little bit of tidbit. We take your
Yeah.
kidney, we give you trivia. It's just a bonus for doing business with the Britney Spears credit card company.
well,
Lurch. If I could just, I mean, can't we just pay the money? I just want to pay this off. Okay, let's just forget about the kidneys. I just want to, make things great, make things even. So how much does she owe?
According to this statement, she owes $14,000, but I'll take cash and small bills in a suitcase and we'll call it a day. What do you say?
And her kidney's fine, right?
I mean, as far as I'm concerned, can't speak for the other people behind me, the second round of collections, but for me, it'll be fine.
Oh my God! And you've already been through some people today, huh? I see some blood back there.
Oh, yes. There was a 12-year-old boy down the block. Don't know what he was doing with the Britney Spears credit card, but we took care of it.
everybody's
He didn't
buying
even have
Britney
parents.
Yeah.
What'd you say, sweetie?
I was saying everybody in school's got a Britney Spears credit card. Everybody's losing their kidneys, right and left.
We cut to the school cafeteria. Sign up for your Britney Spears credit card over here at the lunch table. We're giving out free pencils if you sign up for a Britney Spears credit card. Are you interested in a Britney Spears credit card?
Wow, look at these cool.
Support the cheerleading club.
Wow, look at these pencils, really cool.
Yeah, they have a bobblehead on the top. Come and
Got a
support the
Britney
Britney
Spears
Spears credit card. It supports the cheerleading club.
What do you think, Kristen? You want to do it?
I was told that I should read the fine print before I sign anything, because my older sister lost her kidney.
Don't be a nerd. Don't be a nerd. Are you being a nerd? Don't be a nerd.
Okay, I'll buy one. I'll get one because I want to
cool.
be a cheerleader. Okay.
Yeah. Well, you're not going to be a cheerleader, but you're going to support the cheerleader club. So don't be a nerd. Support the cheerleader club and get a credit card too.
You can't anticipate that I could become a cheerleader. Maybe over time, maybe it's reasonable to assume that that'll be part of the fallout of me even just getting this credit card, is that one day I become a cheerleader because of it. It's a chain of events that happens. You can't stop.
Everybody knows reasonable is a squishy word.
Well, geez, you've got a squishy face.
Oh, wow.
I get that a lot.
Oh, Kristen, what's gotten into you today? My God.
I feel like I'm turning over a whole new leaf. I just honestly, I'm thinking Maybe I should just start a life of crime. I take my Britney Spears credit card and I use it to defraud people.
These are big words, defraud. I just wanted to eat lunch and buy pencils.
You're thinking small.
We cut to the Spencer's store at the Santa Anita Mall. Hey kid, do you want to get some Rick and Morty t-shirts or perhaps a Riverdale sweatshirt?
Those
we
sound
have
really good.
Yeah, we have some Dungeons and Dragons themed bracelets over here, and some goo. I don't know. You want some stuff like that?
Yeah. I want all of that.
This is, by the way, at this Spencer's, we focus on customer service. In case you didn't notice, yeah.
It's really good customer service.
Kristen, you're really trying to change your whole look now that you've decided to live a life of crime. I guess kids that shop at Spencer do look like.
Don't tell them I'm living a life of crime. I'm going to tell them that they're going to give me this stuff as collateral based on my prospective bonus. It's going to work. Spencer's has a really great bartering system.
And then maybe you can get the Spencer's credit card and then just never pay them back.
Oh, okay.
This is an idea.
That's a good idea. Maybe you should be the one leading a life of crime.
All right, so you want me to ring you out? You got 42 keychains, 12 t-shirts, some kind of lava lamp thing.
Is for you.
What's that?
One of those keychains is for you.
Well, flatter me some more.
Oh man, that's not creepy.
Is that a flag I see in the corner of the shop? A Hot Topic or a Spencer's flag?
Oh yeah, it's a rainbow flag, and then it has 7 leaves. And if you know what that means, 7 leaves refers to, you know what it means, right? And it's cool.
People.
It's like clip. Yeah, 7 leaves. That's what it means. It refers to.
Wait.
So yeah, you could get the rainbow flag with the 7. That's cool, man. And
that's really cool.
And
that means wait. So that's not the right flag you're supposed to have in your store. So that means we could just kind of take anything here, right?
That's
because
right.
Yeah, pretty much. I don't care. I'm making minimum wage. I gotta go get my lunch at Sbarro. So can you just I'll ring you out if you're done, because I'm supposed to clock out in a minute.
Hey man. Put it all on Britney Spears, okay? Put it all on Britney.
Baby, I'll hit your card one more time. And
I'll give more.
Oh, it's declined, but that's okay. Just take the stuff anyway. No problem.
Thank you. Panic in the streets. That's right. Brittany already took my kidney. What else can she have from me?
Well, at least you have the other one still. I mean,
wait, what are you? Hold on. Sorry, I'm on my lunch break now, so I'm allowed to socialize and fraternize with the patrons. And I must say, I want to hear more about this kidney. Will you walk with me to Sbarro as I get my delicious lunch?
I would love to walk with you to Sbarro, but can I just say that I anticipate there's a possibility we will run into a greasy floor spot, or we might trip and fall and hurt ourselves over the chairs and tables. And if that happens, I would like for you to agree to pay a penalty of no less than $10 million.
Deal. You got yourself a deal. That sounds like a total winner for me.
Okay, great.
Okay, super.
He's so much older than us. I don't know if we should be going with him, Kristen.
Just be quiet and follow my lead when I fall in a second.
Okay.
Oh no, you fell. I should not have. You both fell. I should not have signed that contract.
Wait, but I fell for no reason, because I didn't sign a contract. I just fell and hurt myself. I'm not getting anything.
He's hardly a future lawyer.
The moral of the story is always sign your penalty provision before you intentionally slip and fall on a wet spot in the mall.
Don't call it a penalty provision. That's a trick of the trade. Call it a liquidated damages provision. Yeah.
All right. Well, that's our show for this week, folks. Before we go, I want to give Henry a chance to shamelessly plug himself. We mentioned something about the West Side Comedy. Can you tell us a little bit about your show?
Yeah, it's just every Monday. It's a great group of people that meets, and anybody can just come up and do some improv at the West Side Comedy Theater in Santa Monica, right off the Promenade. So it starts at 10 p.m. every Monday, 10 p.m.
10 p.m. on Mondays. Great. And where can people find you on the internet or socials?
Let's do Instagram. At Henry the David. You know, pretty simple to remember. And if it's not, then I guess you'll never find me.
All right. So follow him. Do not DM without, friending him first or whatever. I don't know. I don't understand how that stuff works. Kristen.
Yes.
Where can people find you?
I am newly cast in a show that will be running every Friday, which is super exciting for ad infinitum, apparently. So,
Wow.
Called The Rendezvous, and it's a close quarters format. Come check it out if you're in Austin, Texas. Come on
Austin,
out.
Texas.
Yeah.
The Rendezvous, Austin, Texas. What is the Rendezvous about?
Rendezvous is a team, does close quarters format, and we're at Cold Town Theater, and we just got formed, and we didn't make ourselves, they made us, and I don't know much about it other than that, but I know it's going to be a romp. It's going to be great.
What is close quarters? I'm not familiar with that term.
It's a really cool improv format where you are not in one room, but like you're in like one overarching area, like an airport or a mall or something. So you can be in component places within that overarching area, but you're going along a continuous timeline. So like if you hear a sound in one scene, you might hear it in another scene, like, you know what I mean? Because
that's cool.
You're all in the same place at the same time. Yeah.
Yeah. Like you're in a mall and then you're in a Spencer's and then you're at a Sbarro, that kind of thing.
Exactly.
Except we didn't really sustain it like that, but awesome.
Yeah, very cool.
All right. Well, check out Kristen if you're in Austin, Texas, or find her on the socials at.
My Instagram is Kristen Drenning with no spaces or anything, just KRISTENDRENNING.
All right. Thanks so much. Well, let's say goodbye, folks.
Bye.
Bye. I'd like to thank my crew today, Kristen and Henry, for joining me on the show as we descend to insanity.